Szypula. I'm not sure if I'm pronouncing it correctly. Szypula v. Szypula.
Szypula, very well, Your
Szypula?
Honor. Szypula.
Szypula.
So, may it please the court, my name is Jim Miller. I'm with the firm of Miller Mayer in Ithaca, New York, and I'm here on behalf of Meredith Szypula. I would reserve 5 minutes, if I may, for rebuttal.
Sure.
First of all, I want to thank the court for taking this appeal. 236 of the domestic relations law defines property. It's a classification of property. It defines all property that is acquired during the marriage is marital property. Pretty simple. Property that's acquired during or prior to the marriage is separate property. In Dolan, this court said that pension rights that are earned or acquired prior to the marriage are separate property. So the question for you in this narrow case is clarifying for everybody in New York what it means to earn property rights prior to marriage. And I'm going to suggest a very simple rule in this case. When you have a contributory pension system, such as we have in this case, and you never become a member, you never become a participant in that system, much less you never make any contributions to this system.
But was it a contributory system in the Navy?
It was a contributory
So
system.
he
That's the whole
should-
point.
But he should have been putting money into that system and deducting it from his pay at the time he was in the Navy?
And if he's a participant, he's required to do that.
How do we know that?
Yeah.
How do we know
Where,
that?
where is that in the record?
So the record here is I brought a motion to classify this as a marital property. That was done in chambers off the record with Judge McBride. And we pointed to the Burke case.
So the assertion that the Navy pension did not require contributions
No.
it would be incorrect.
It did require contributions, absolutely. It required contributions, and that's why you were able to buy it back.
No, but my understanding of that, and maybe this is just not accurate, was when you transferred whatever the years were here, 11, from the Navy system to the state system, the federal system required you to buy the equivalent of that time that you would have paid in if you had been working in their agency.
No.
But
He was
again,
always an employee of the federal government before and
The
after.
military may have a very different pension than the State Department, right? In the military, I could see you not having to buy in.
No, well,
I guess what I'm still struggling with is there somewhere in the record of this case where we can see that he had to contribute to the Navy pension?
okay, Your Honor. As I said, this motion was argued from a Judge McBride in chambers.
Right. So
There
does that
was a
mean?
discussion
No.
about
Does that mean
It
no?
was understood, and it was admitted that he was never a member. He
Okay.
never bought into it.
But he was in the Navy before he ever met her, correct?
Correct, absolutely.
And because he was in the Navy during a specified period, he was eligible at a later period.
No. It just, look,
Okay, follow me. Before he ever met her, he was in the Navy. That is uncontroverted, correct?
for 9 years.
For 9 years. And it is because of that service during that specified time that later he could buy it.
No. No,
So
absolutely not.
where does the right come from?
Right,
And
the
where
right
does the
comes
record
from-
support it?
So the right comes from, he leaves the Navy 3 years after the marriage. He's got 12 years in, 9 premarital, 3 marital. He leaves the Navy for 14 years, enters a private practice. He has no pension rights whatsoever. He goes back to the federal government, his original employer, and the federal government says, look, as a benefit of your current employment, if you join the pension plan, and if you pay into the pension plan, then we will give you the opportunity to purchase those credits.
Credits based, though, on years, I'm right here.
What?
Credits based, though, on years of service
No.
that, okay, so presumably, this is not, like some investment and where you're simply buying a stock or a security. My understanding, but if I'm wrong, correct me, please, is that what he is being allowed to repurchase is the credits from the 9 years plus the 3 years during the marriage that he served in the Navy. Am I wrong in understanding that? So that then he can vest and hit 20 or whatever the vesting number is with that 12 credited towards the
What
vesting.
he's allowed to pay is what he would have paid based upon his salary, not the years of service.
I understand,
based
but
upon
if
his
he
service.
had not served the 12 years in the Navy, he would not have had any option to do this. Is that right?
That's correct.
Okay, and so he has earned the option, whether he let me finish if I could, please. He might not have exercised the option, but the years that he spent in the Navy, which are necessary to earn the option to do that, 9 of those were prior to the marriage. Is that right? Let me put it differently. If he had not spent the 9 years in the Navy prior to getting married, plus the 3 during his marriage, would he have been able to do this?
No.
Okay. And so what weight does your analysis give to the 9 years of time that he put in prior to the marriage?
Because it's not a basis of the service. It's whether or not you are a member of the plan.
So I take it the answer is it doesn't take
makes
it
no
into
difference.
consideration.
So is your argument that he was a member but a non-contributing member, or that he was not a member in any way of the Navy pension system?
Not a member in any way. And that's the rule that this court should adopt, that if you're not a member.
Hold on, because, as state employees, we have some passing familiarity with our own pension systems. And my general conception is that when you buy back time, you have to buy back eligible time. So in other words, you might have had a number of years in some eligible pension system, but you can only buy back the number of years that you had. You're saying here, the State Department just said, give us this much money, and we'll credit you as if you had been a member of the pension in the Navy for 12 years?
You're allowed to buy back, as a benefit of his employment, the federal government says, look, you should have paid based upon your salary, not years of service, based upon your salary, which is basically, it's the same as Social Security. You can.
I have to stop you right there, because I don't understand this distinction about based upon your salary, not years of service. The number that state is saying, pay us this much, has to be reflective of the time. You're buying back time.
You're buying back time, but the payment that you're using, that
So-
you're paying, is based upon
Would
what
the-
you would have paid into the system if you had been a member.
Sorry, into the Foreign Service system or into the Navy system?
Into the Navy system.
So to the,
So if he had only been in the Navy 1 year, would the amount have been the same?
No, it would have been whatever he would have owed for that
So
1
the
year.
number of years does affect the cost?
Correct.
Okay.
Correct.
and,
So, I mean, just-
and if the pension plan were otherwise, and he did not have to pay in, but accrued years of eligibility that didn't vest until some, 20 years or whatever, pick your number, would you still win, or do you lose if that were the case?
if he's a member of the pension
If
plan,
he's,
and
by
that
what I
vests
mean,
over time,
if it vests over time, so that you accrue eligibility with each passing year, but it doesn't vest until year 20, say,
Sure.
you say you would not have a claim that it's marital property in that circumstance. So
no,
if the record is not clear on this point, what are we to do about that?
what you need to do is have a rule. And if you want to send it back to the court, and we can have more testimony, that's easy. But the rule has got to be that if you are not a member of a contributory plan and you never contribute, you are not earning pension benefits. Your Honor, I started my career off as an assistant DA, for 8 years. First day, I sat down with the county HR department, and they said, look, you can either join the system and pay into it every year and accrue some benefits, but oh, by the way, if you don't stay for 20 years, it's all
Not going to
gone.
invest, yeah.
Or you can keep the money, in your pocket and not be a member. I elected not to be a member.
But what if the military's different than that? What if the military says, and I don't think we can tell from this record, you serve the country in the military for 20 years and we'll give you X pension? What if that was the case?
Well, if it's a non-contributory plan and you're a member, absolutely. It is
Then it would
separate
not
property.
be.
Absolutely.
But-
Well, wait.
But I thought the pension is not the Navy's pension. Have I misunderstood this from day one?
No, you're correct that the pension is the federal service pension, or federal,
That's the pension
right, it's
that
a
he
federal
receives,
government.
that's the pension they're fighting over? Okay.
Correct.
All right.
Correct.
So his eligibility for that depends on what he did prior to the marriage. But the property itself is this pension that now exists
That's- Right.
while he's married. Let me
Right,
just
and
put
you
it
can
that way.
supplement that. You can buy back increased pension benefits by paying to your employer, the federal government, which was the
But
same as
he would not have that, I think Judge Halligan asked this before, he would not have that pension, but for the fact that he's got to buy this time
That's correct.
in the Navy, even though, I think I'm understanding your argument here, even though when he was unmarried, he made a decision not to join that pension plan, but once he's married, he's now making a decision, I want this pension plan.
That's-
It's like any other requirement to join that pension plan.
Sure.
So let me ask you, let me ask you a hypothetical. Suppose we assume that the pension plan from the Navy is non-contributory. That's, everybody's entitled to it no matter what, right?
Absolutely.
And then what happens is exactly what happens here. So we would assume then, for the sake of my hypothetical, that the 9 years is separate property.
Absolutely.
And that separate property and then some marital property in the form of something like $9,000 is used to purchase an enhancement to the Foreign Service pension. What then is is all of the Foreign Service pension marital property? Is some of it marital property? How do we determine that value?
Excellent question. There are two ways to look at this, okay? So we talked about whether or not, how do you define that pension benefit. The other thing is the purchase. So just remember, go back to the very first thing I said. Property, all property that is acquired during the marriage is marital property. The appellate division states, in their opinion, they made a finding, this property was acquired with marital funds during the marriage.
Well, in my hypothetical,
and
it's a
there
mix, in my hypothetical, it's a mix of
I'm
things.
going to
It's
come
some-
to you.
Okay,
If you may just.
yes, of course, go ahead, sorry.
So they made a finding that it was acquired during the marriage, so it is marital by definition of the statute, okay? What they then did say is, oh, because that property right that you acquired was associated with a pension that had some service premarital, we're going to make that separate property. You can't do that. Go to your question. If you use marital funds during the marriage to acquire property, it's marital property. You may have a separate property claim. We're used to doing that in my business.
So are you treating the time that the earned option that he acquired before he married, those 9 years, as if it were a house? Because you're saying, well, you bought it during the marriage. A house is still a house if you buy it in one period or another period. But that which, the only way he could have benefit of this bump up is because of that prior naval service well before he was married.
No, not at all. Absolutely not.
Okay, so you're saying.
You can only get that if you pay money.
No, wait. The 9 years of service in the Navy had nothing to do with the ability to get that extra.
Absolutely. I don't say that. I don't say that at all.
That's what you were suggesting.
No. What I don't say that at all. But the reason he was able to do that because as a benefit of his new employment for the Foreign Service, they tell him, look, as a benefit, if you keep working for us, and if you join the system, and if you pay into the system, we will allow
Two
you
things
as a
can
benefit.
be true, but ultimately, as to the sharing, part of it gets cut up at the end of the dissolution of the marriage one way, and another part gets divided another, because they're coming to the marriage in different parts. Part of it is because of the naval service, but if he didn't go back into service, then ultimately, it is correct, he wouldn't have then had the ability to have ultimately the greater pension benefit.
That's correct.
It all worked together.
Yeah,
That's
how
correct.
do you divide up, I want to buy whatever it is when we're married. We use marital funds. Nobody's going to debate that these are marital funds that we're going to use to purchase, but it's not enough. We only have 20,000, we need 30. I have my private money, my own money, that I had before this marriage. I've kept it off in some account that my spouse cannot touch. I say, okay, I really want us to have this. I'm going to take that money so that we can buy this. How would you divide that up?
We do that all the time in my work.
Yes, I know, that's why I'm asking.
So let's just make it simple.
Yes, please.
I earned $200,000 during our marriage, okay? My wife has inheritance,
Yes,
for
yes.
money that she had, $200,000. We buy a $400,000 house.
Yes.
The law is clear. That house was acquired during the marriage. By definition of the statute, it is a marital asset. She now has a claim for a separate property credit. She can come in, it's her burden, but she can come in
Say
and say,
it was
"I want a
was
separate property
non-marital
credit."
property that we used to purchase this. I want back 200,000.
Absolutely,
Is that
but
correct?
it's
And divide the
classified,
house, and I want my 200,000.
it's classified as a marital asset,
Uh-huh.
subject to a separate property
And
claim.
let me just ask you about that. Suppose that $400,000 house is worth $1 million at the time of the divorce. Assuming that she can prove her separate property claim, it entitles her to the $200,000, not the appreciation. The appreciation is the marital asset?
Fortunately, that issue's been litigated many times.
And I just want to make sure I have the answer right.
It's 200,000.
Yep.
You have a separate property credit
Right.
for your contribution, regardless if the price of the house goes up or down.
Right.
You're going to get your credit, you're going to be put back in.
And
the
so
same
here, if we viewed, and I know you don't view this way, but if we viewed the 9 years as separate property of Mr. Szypula, if we viewed it that way,
Szypula.
right? If we viewed it that way, and if he could prove that it was separate property, right? He goes through whatever claim he has, he would get the value of that.
Yeah,
And what is the value of that?
it was zero. That was very simple. When
Wouldn't
he
it
left
be
the
the amount
military,
that
he
they
had
paid?
zero.
Did you not say in the beginning that the state pension system said, give us this much money and we'll credit you for those prior years? And wouldn't that be the value of that?
Just to clarify the record, these are federal systems.
When I say state, I mean Department of State, not the New
Oh,
York
okay,
State.
I'm sorry. So I apologize. Can I ask you?
So to go back to the question, in this determining this contribution of premarital assets, wouldn't the value of his premarital asset be the amount that the State Department Foreign Service pension system asked him to pay in order to credit the 9 years of premarital service?
Because everybody agrees that that cost was marital money. They said, you have to come up with $12,000 out of your pocket that you earned. It took them 6 years to save money during the marriage to pay the federal government $12,000, and then they got a credit because they overpaid, but let's just call it $12,000 to buy those credits.
Because that was
that
the
was
value,
marital
but isn't
money.
that because that was the value of those years in service of the Navy?
No, because that's how much he would have had to pay
Into the Navy
into the
pension?
Navy. And so basically, the federal government says, look, as an incentive, as a benefit of your employment, the fact that you didn't pay it when you were young, because we all make mistakes when we're young, as a benefit of employment for working for us now, you can pay that in. And we're going to not worry about the fact that we didn't have the use of that money to invest or whatever to increase that. We're going to allow you to buy that for the same money that you would have paid if you had been a member. He was never a member. If you're not a
He was
member.
never a member because he chose not to be a member.
Exactly.
Not because he wasn't
Absolutely.
allowed to, or there was some restriction.
Right.
He made a decision, I'm going to forego paying this because I could use the money
Right.
and in some other way.
Absolutely. And again, the rule I'm asking you to adopt is, if you think the record's not clear, you can go back. But the rule I'm asking you to adopt is, in a contributory pension system, if you elect, you decide, I'm not going to be a member, I don't want to do that, then you can't ever be said to have earned or acquired property. 'Cause
But not if it's a non-contributory system is the converse. I take what you're saying.
Absolutely.
Okay.
Absolutely. If it's a non-contributory system, your service, the fact that you serve, that's a separate property credit. But the-
Thank you. Let's hear
Thank
from,
you.
you have your
Thank you very
rebuttal.
much.
Well, yeah.
May it please the court, Emily Barnett for John Szypula. This court has repeatedly applied a clear rule for determining when pension benefits are acquired. They're acquired when they're earned, and they're earned incrementally during each year of service as deferred compensation. Mr. Szypula had a benefit when he left the Navy.
Did he have to contribute during his time in the Navy or not?
So I don't think that this is in the record, but my understanding is that the Navy had a non-contributory pension plan at the time that Mr. Szypula was serving in the Navy.
So what do we do about the fact that the record doesn't establish that if we were to decide that it's relevant to the outcome here?
Well, I also,
I mean, the property is presumed to be marital, right, unless it's established otherwise, I think. So if there's not sufficient evidence in the record to show that it's non-contributory, as you say, and we think that that matters, what do we do?
I think it would be appropriate to remand in that case with instruction that the court should conduct fact-finding as to whether the Navy pension plan was non-contributory, and if it was, then the decision below should be affirmed.
And why is that not, a second bite at the apple, if you will?
Well, I will say I think the closest that there is in the record to suggesting that the Navy pension plan is not contributory is on page 893A, which is Mr. Szypula's testimony during the
But
trial.
I take that, but I'm asking if we were to conclude that there's not enough in the record, you think we should send it back? And I'm just asking, why would we do that as opposed to taking the record as we find it?
I mean, the Ms. Szypula petitioned for review, and this court granted review, and I think that at this point, it would be
Let me
appropriate-
ask you this, with respect to the definition of property. If Mr. Szypula had not served those 9 years with that which they are fighting over, by whatever name you call it, would it be available to be split up?
No, it would not be available to be split up if he had not served the 9 years
So
in the Navy.
what value, if any, who does that belong to? He couldn't necessarily cash in before he married, but he served. Is it worth something? And does she get benefit? It becomes marital property solely because of when funds were used? And how do you separate out the fact that he served, or is it irrelevant? It's just all about when the time came and he bought it.
So I think this court has adopted a clear rule that all that matters for determining when a pension benefit was acquired under the domestic relations law is when it was earned. And this court has addressed a number of cases where there were contingent features, where the pension would have been worth nothing if something hadn't happened after those years in which the pension was earned. The husband had to keep working so the pension would mature. That was Majoskis. The husband had to keep working so the pension would vest. There was a change to the pension after the party's marriage that changed the value of the pension. But none of those things mattered. All that matters is when was the pension benefit earned? That's when it was acquired. And the pension benefit that you earn is whatever the pension benefit is, as it's ultimately determined when the person retires.
Well, does
So
it
how do
matter
you-
that this is not the Navy pension? It's a different pension? And they have different rules and different requirements, and he's complying with those requirements to be able to get that pension. Does that matter? I mean, I could see somewhat an argument if the Navy allowed him some way to buy these years later, when he says, you know what? I'd like this pension. I want the pension from the Navy. So, and he buys that back in some way or another, or he does whatever they require to get that pension. But this is a wholly different pension plan. Yes, it's the federal government at the end of the day, but it's different rules and requirements from that federal service of the Department of State.
So I don't think that matters, because I don't think it changes the fact that the Foreign Service is compensating him for his time in the Navy. There's a very concrete tie between the additional 9 years that are added to the calculation of his pension benefit under the Foreign Service Pension Plan that are tied to the 9 years in the Navy he served before the marriage. And this court's cases say that what matters is the person being compensated for the prior years of service? If so, that is when those benefits are deemed acquired.
Suppose we think that the 9 years is separate property, right? That's a pension credit that was earned. And that was used, and some amount of cash that's marital property was used. The two were used in combination to purchase the Foreign Service pension. Is that a fair characterization of what happened?
Yes, that's.
Okay, so then, is counsel wrong to say then what should happen is the whole thing is marital property, but Mr. Szypula has a claim for the value of his contribution to the pension? Is that the way it would work?
The way it would work is that the portion of the pension that's attributable to Mr. Szypula is 9 years in the Navy
Well, but that
before.
gives him, that's different than from the rule that would apply if this were a house, for example, where the appreciation is marital property. And all you get back is your contribution. So here, if we were using that set of rules, I think, what you'd have to do is value the 9 years and say, what was that 9 years worth at the time the contribution was made? That may be a pretty hard thing to do with an inchoate pension, especially one that, as Judge Rivera was pointing out, isn't actually the pension that he ends up getting paid.
I think that that's not the right way to think about it under this court's cases, Your Honor, because the court's cases say that you have, and I'm quoting Olivo here, that what the right to the pension you have is the right to the pension as it's ultimately determined. And so it doesn't matter that some contingent feature happened later on that changed the value of the pension. It's not deemed marital property just because the contingent thing that increased the value of the pension happened during the marriage, if the pension benefit
But again,
was
why
separate.
doesn't it matter that it's not the same pension? You're not talking about the same pension. You're talking about a different pension. They have different requirements.
Your Honor, I would give the same answer I gave before, which I think that what matters under this court's cases is whether the individual is being compensated for past service. And
For a particular outcome in that pension system, you're now for a different pension. I mean, that's, I guess, why I'm having some difficulty with
Yeah,
this
well-
particular argument. Let me ask you this, what's the difference between what the appellate division did and what the chief judge has described and what counsel argued was this separate property claim that Mr. Szypula would have?
I'm sorry, could you ask that one more time?
I'm sorry. I just want some clarity on what the appellate division did, the way they decided to determine what each party is entitled to, what they remitted it to the Supreme Court to do. Because I think there is a difference between that and what counsel is describing is the way one should resolve this case. I just want to hear from you if you think there's a difference and what it is.
So
Does that help?
what the appellate division did is said that the portion of the pension that is attributable to the 9 years in the Navy is entirely separate property, but about approximately $9,000 of marital funds that the parties put in remains marital property such that that is subject to equitable distribution.
Is your view the same regardless of whether it's a contributory or non-contributory pension? Does that matter?
I don't think it matters because of this court's cases saying that all that matters is whether you're being compensated for your past service.
But isn't there a different decision that's being made if you didn't contribute prior to the marriage, and then during the marriage, you make a decision to purchase credits, and then that becomes an asset that you can rely on, is it perhaps, is there a better argument that that's earned during the marriage than if it was non-contributory and those years were accruing without any choice made? I mean, the deferred compensation concept to me seems maybe to apply differently in those two circumstances. You're pocketing the delta if it's contributory, I think, and you choose not to contribute, right?
Yeah, so I understand what you're saying. I think that maybe the most helpful case on this point is not a pension benefit plan, but De Jesus, which involves stock options, that was sort of in the same line as Majoskis, and this court has construed other employment benefits that are deferred compensation along the same line as pension benefits. And in that case, the stock options were an entirely new benefit that only came into being during the marriage. But the
Yes.
court still held that to the extent that those stock options were intended as deferred compensation, they
Yeah,
would be separate property.
I think that's what I'm asking. So if it's a contributory pension, I presume that if I choose not to contribute, that I am pocketing whatever the money is that I would otherwise pay in each month in order to be accruing pension eligibility credits, yes?
Yes.
And so it seems to me that perhaps my compensation is not deferred. I'm actually getting it in the moment because I'm choosing not to put it in and accrue the credits, much like I would with a 401K, for example. So why wouldn't we treat them differently is my question.
I think under De Jesus, it doesn't matter whether in the time that you are, for which you are being compensated, you are being paid less, because I don't think in De Jesus, the husband was being paid less in the pre-marital time.
But if deferred compensation is the touchstone, then why wouldn't we assume that, you're choosing yourself whether to contribute or not? There's no aspect of deferred, there's nothing deferred about it.
Well, as I said at the outset, in this case, my
Yeah.
understanding is the Navy plan is not contributory, and, this court could decide.
Let me ask you this, with respect to, there's questions about whether it's two different pension systems, or they're different, but the two are joined together, whether you call them, one is State Department, one is Naval. Ultimately, the payment that is received upon retirement, it comes from one pot, correct? And and one is impacted by the other. So the prior service impacts what you ultimately get.
Yes, that's right. And also, I'll say, this is not, I don't think this was in the briefs or in the record, but federal government pension systems they're governed by a comprehensive federal statutory
It's just like
scheme.
the state of New York. If you work for a county and then you work for the state proper, ultimately, if it's part of the same pension, they come from the same pot. The amounts are impacted, though, by the contributions during the relative periods.
I guess,
Ultimately, you're paid from one source. They're paid from the federal government.
that's my understanding. There's nothing
But
in the record
what
about that.
he and she ultimately get is impacted by all the service that occurred here. The 9 years impacts the later State Department portion and the marital portion that she gets. To the extent that the marital portion is enhanced, she gets more. And to the extent that the other part was separate, but they all go together. They all impact one another, correct?
Correct.
So,
And-
I'm sorry.
Okay.
Do you have an understanding of why, if the Navy plan is non-contributory, someone would have to make payments to the Foreign Service?
So again, this is not in the record, but my understanding is it's sort of to treat individuals who are buying Navy credits fairly with individuals for whom their entire Foreign Service pension is coming from years in the Foreign Service, so that they're treated as if they had been in the Foreign Service in those years and had been paying in.
Isn't that how all buyback plans work? When you use time from a prior employer to buy back time under your new pension plan, you're being asked to contribute what you would have paid had you been working for the new pension employer all along, right? I mean, they're not asking you to contribute your contributions or lack thereof from your prior employer, or am I wrong about that?
That's my understanding, Your Honor.
Can I just ask you one other question about valuation? I mean, and I guess this relates to something Judge Halligan was asking for, where it's a non-contributory pension plan, and you're making a claim of separate property, earned under Majewski's back in the day when when he was working for the Navy. How do you value that?
How do you value, I mean.
What's the methodology for valuing time under a non-contributory pension plan?
Well, the value of in this case, the value of the 9 years of his time in the Navy before the party's marriage will be, he's planning to retire at age 65, I think, in 2030, and so it will be 9/29ths of whatever his pension plan pays out, because my understanding is the formula for calculating your annuity under the pension is something like the average of your 3 highest salaries times the number of years times some percentage. And
So it's the enhancement to the value of the State Department pension, basically.
It's the portion of the State Department pension that's attributable to his time in the Navy. And Your Honor, if I may make just one last point, I believe this court's cases holding that pension benefits are earned when they're required resolves this case. The rule is a good rule. It reflects economic realities. It's administrable and it's equitable, and there's no reason to depart from the rule in this case. And awarding Ms. Szypula the portion of Mr. Szypula's pension that's attributable to his 9 years in the Navy would give her a windfall. They paid a $9,000 administrative fee, and again, this is not in the record, but it amounts to roughly somewhere between $10,000 and $20,000 a year. And the value of that pension benefit is coming from Mr. Szypula's years in the Navy. It's not coming from the $9,000 administrative fee that the parties paid.
Thank you.
Thank you.
If I may,
How many years to vest?
20. So every case that this court has held before, the Dolan case, the DeLuca case, all these Majewskis, people the title spouse were participating in the pension system. They bought into the system, okay?
And wasn't it also in those cases that the earned date and acquired date was the same?
So the earned date and the acquired date,
Like, I think that
I guess, yes,
Majewskis
yes,
used
in a
that
sen-
interchangeably, earned and acquired.
right. But let me just, if you're going to be intellectually honest with the framework of the equitable distribution statute, the statute says if you use marital monies during the marriage and you acquire something, that property right is marital. The third department said, quote, marital funds were used during the marriage to acquire a property right. But then what they said is because that marital property right was associated with a pension that had some service component to it, we're going to convert that to separate property. There is nowhere in the statute where any court, there's nowhere in the statute and there's no case in this state where any court has converted a marital asset to separate property. You can't do that. And that's exactly what the third department did. They said, you used marital property during the marriage, you acquired, this is their language, you acquired a property right.
But your I'm sorry, but your position is that the 9 years in the Navy as an unmarried individual, right, has a value vis-à-vis this pension, and he could have a separate property interest in that, correct? Or did I misunderstand you?
And absolutely, he could try to assert some separate property claim. Okay, my position would be that that was worth zero, but that's what the valuation, and Judge Trauman, that goes to
Well, he
your
has
point
a
about
thing.
classification
No,
versus value.
no, but he has a thing. You have a pension system that says, we're going to put a number to that. We're going to give value to that. Up to you if you want to actually let it go and put it into this system. It's that externally, there has been value given to that. He's always had that service. That service doesn't disappear, right?
Absolutely. But
Right,
that
okay.
service didn't earn him anything when you're not a member of the pension system. If you don't participate,
I understand, but the time in, apart from the benefit the United States, all of us gained from his service, the pension, the State Department, yes, the federal government's, does give value to that later on. Whether they contribute or not, doesn't matter. They're giving some value to that, and they're saying, if you want, we're going to value that. This is what you can do with what we would value.
and you have to pay marital funds, $9,000, which is exactly what you would have had to pay in the contributory plan.
Okay, well, that's how you would value it, but I'm not sure I'm all about, it has zero value. I'm not sure that
But,
completely
the court
makes
doesn't
sense
have
to
to
me.
go there.
I mean, right, I mean, to Judge Rivera's question, so he works 9 years, or 12 years, I guess, in the Navy, and leaves the Navy, right? I work 12 years in the private sector that doesn't have a Navy pension at all, and I leave, right? We're both now employed in the private sector in different jobs. He, though, has some benefit that I don't have because he has some ability to transfer that to other government service. I don't know what that value is, but he's better off than I am.
That's a benefit of his current employment. His current employer, the federal government says,
No,
well,
no,
as
put
an
us, no,
incentive.
but he, doesn't he work in the private sector in between?
He worked for 14 years.
In the private sector. So
Absolutely.
now we're just talking about the time that he's in the private sector.
Right.
When he's working in the private sector, he still has, he's a little bit better off, or maybe somewhat better off, we have to figure out what the valuation is maybe, but better off than somebody who'd never worked for the Navy, because he has the option to go to work for the federal government and get a benefit. He's a little bit better off.
When he's in the private sector, he has no pension benefits, absolutely none
But he does have a
whatsoever.
contingent
if
interest,
you
does
could-
he not?
But he has the ability, if he goes back to the federal government, as a
Right.
benefit of his current employment.
So
I
to the
agree.
federal government, there is value. He has something of value.
The federal
That's what I'm
government is
saying.
willing to give him something if he pays, if he joins the system, he works for the federal government, he pays into the system, and then he buys that
Right,
back.
right.
And he had 9 years of service, or
And
12.
he-
Yeah, but all of
Because
that
without
would be,
that, you just can't buy back.
You can't get an offer to buy back 11 years unless you work 11 years.
Absolutely.
yeah, but isn't the question, like, first you have to decide if it's marital property or not, and then secondly, you'll determine in the equitable distribution of that, all of those things, how much time he did versus what the wife did, et cetera. Like, I feel like that's a separate consideration. Our first one
That's a valuation, I agree. And the only issue before this court
is
is
whether
the
or not.
classification of the purchase with marital funds during the marriage of those credits. Are those credits that were purchased during the marriage with marital funds, is that marital property? Or is the third department said, oh, it's marital, but we're just going to convert it, make it separate property? You can't do that.
Thank you.
Thank you very much. Have a good day.